Le juge Binnie n'a pas besoin d'introduction lorsqu'il y a des étudiants en droit qui l'ont lu tellement souvent et qui l'admirent tant que ça. Il a eu une carrière extraordinaire, une carrière qui a marqué la profession juridique, qui a marqué aussi le service public et évidemment le pays tout entier. Lui doit beaucoup et je me joins un peu aux bons mots qui ont été exprimés pour lui dire toute la reconnaissance que nous avons tous pour tout ce qu'il a fait pour nous. As you know, Justice Binnie is here. I cannot thank him enough for being here in Calgary tonight. You know how much he's contributed to Canada. I'm not going to detail his long biography. You read him, you like him, you disagree with him, sometimes you agree with him, but tonight we are so pleased and so honored that you have come to this RightsWatch conference. Merci beaucoup.
Merci Nathalie pour vos mots très chaleureux. J'ai l'impression que c'est un peu naïf de penser que tout le monde lise les motifs de jugement. Mais quand même, c'est une bonne pensée. It is true, have been retired now for 6 or 7 hours. I'm already feeling liberation. I will probably say things that I shouldn't say, that you will hope and I hope not. But it is quite a rite of passage. I first appeared in the Supreme Court of Canada in November 1965 and have been there off and on as a lawyer and a judge for 46 years. Until today. It is extraordinary, and this I will develop a little bit, the faith that people have in the courts today, which is so different from the attitude people had when I was called to the bar. The Supreme Court of Canada at the time was filled with some decidedly peculiar people. I'm not saying that today we're typical of the best the country has to offer, but we are less peculiar than the court of the 1960s and 70s. When I first got there, Chief Justice Taschereau presided, and his habit was always to wear sunglasses in court. And the assumption was that he was asleep, and I think it was a very valid assumption, but it was unprovable either way. Justice Pigeon had the most shrill voice, I think, that ever graced a courtroom, and if you were an unfortunate counsel, you had this constant usually beside the point, and you would have to soldier on hoping that at least the other 8 were listening to what you had to say. Justice Abbott, in a move that would be unthinkable today, came directly from the Minister of Finance to a seat on the Supreme Court of Canada. And nobody really raised much of an eyebrow. It was all part of the governing establishment. And my personal favorite was Wilf Judson. Nobody ever hears about Wilfred Judson anymore, but he was quite a significant force in the judiciary in those years. And his great physical charm was he had this incredible comb-over, what we would now call a comb-over. And it was referred to at the bar as the Greyhound cut, on the basis that he made a little hair run a long way. echo the Mayor's comments about the importance of RightsWatch and the work that is being done. And I'm going to develop a little bit the theme that the human rights community in Canada has swung too far, really, into a reliance on the courts and have moved away excessively from the public education function, the political action function, which historically has been the strong point. That is not to say that on the Supreme Court, the interventions by the Canadian Civil Liberties, BC Civil Liberties, Alberta Civil Liberties, all of the groups are not greatly appreciated. And the reason in particular is that, unlike when I was called to the bar, there is no longer a Supreme Court bar. At the time, there were perhaps 20 lawyers who handled probably half of the appeals that went to the Supreme Court. And they were drawn from right across the country. And so those lawyers had a tremendous background in the way the judges thought and in the case law that the judges were dealing with day in and day out. Whereas today it's not unusual for a lawyer to stand up and start explaining to us the facts of the Oakes case. Well, the Oakes case is cited about 20 times a week. After 14 years on the court, I mean, if I don't know what the Oakes case is about, I'm never going to know what the Oakes case is about. The lawyers who come from organizations such as yours have made a specialty in human rights issues, equality issues, freedom of speech issues, freedom of religious issues. So they stand up with a background in the subject matter, which is essential because the lawyers for the parties very often don't have much of a background in the human rights law or in the charter. They've just got hold of a case and they're riding it all the way to the Supreme Court, and the court will somehow figure out an answer to the problem. So when the court is criticized, as it is from time to time, for an over generous attitude to bringing in interveners, we do so for a purpose. It is absolutely essential to the functioning of the court that we have the kind of experienced counsel that you provide. When I looked on the website of RightsWatch and saw this emphasis on public education and the mobilization of public opinion on civil liberties issues, you'll have to forgive me, I have a cough, which is the price of paying, kissing my granddaughter. I'm sure we'll get through it one way or another. There's no rum in it, so...
That would fix it.
But at the time that the charter was brought in, it is important to understand the orientation of civil rights groups, which was decidedly not towards the courts. In fact, Alan Borovoy, the patron saint of the Canadian Civil Liberties, was very much against the charter. And for the reason that he felt that, first of all, as he put it, he wasn't really interested in being governed by the preferences of a bunch of what he called judicial oligarchs. And he much preferred the members of Parliament who were vulnerable to political pressure that he was expert at developing. And he was in favor of the notwithstanding clause for the same reason, that this was a way in which the members of Parliament could impose on the judicial system ultimately their view of civil liberties. It's interesting being in Lougheed House, sorry, because of course Peter Lougheed was a firm opponent of the charter. again on the basis of the erosion of parliamentary supremacy, as was Sterling Lyon in the deal with this. I do have a cough drop or two. Sterling Lyon in Manitoba, and the judges were against the charter because they felt this put on them a burden which they weren't ready to assume. And it was a partisan issue. It was said in Ottawa at the time, the Liberals having been in power for some 20 years, having appointed most of the judges, that the charter simply represented a huge transfer of power from elected Liberals to unelected Liberals. There was a very good reason, thank you, to be concerned about the way in which the judicial oligarchs would treat the charter. The court, as we all know, had a very poor record in dealing with the Diefenbaker Bill of Rights. It wasn't the strongest of instruments to start with, but what teeth it had were quickly pulled by judicial interpretation. And I think this concern, which people like Alan Borovoy had, has to some extent been borne out. That difficult issues are punted into the courts, not by deliberate action, but by inaction. And if, for example, there is a debate about police powers, and one of the things I applaud your groups greatly is this, these inquiries into the G20 policing issues and the G8 policing issues. I don't know what the facts are, but there is clearly an enormous, enormous issue which the public simply has to understand is of great significance to the functioning of our society. And that is the kind of political mobilization that historically has been the function of civil liberties groups in this country. But the problem with the charter, of course, is that governments can say, well, if there's a problem with the police, take it to the courts, let the judges decide. If the judges say that it's consistent with the charter, then you've no complaint. Well, there are many things that are consistent with the charter which still leave lots of room for complaint, and that room used to be the field of political discretion, and it is important that feet be held to the fire on issues that are policy, even though they are within the overall ambit of what the charter permits. I was the Associate Deputy Minister of Justice in Ottawa at the time the charter was brought into force. My background was in private practice, but I did spend some years in Ottawa in the litigation end of the department. And it is extraordinary looking back at the underestimation by the department of what the charter meant. Judging to some extent on the experience with the Bill of Rights, but more broadly on a view of where the judges were likely to go with the charter, it was seen as a useful but not game-changing instrument. And we went into court, for example, defending writs of assistance. Writs of assistance were possessed by the mounted police, used mainly in drug raids, and they provided that the police could go in on reasonable grounds without any authorization from any judicial official and do a search and seizure. And we thought, well, it says that they can only do it on reasonable grounds, so who could object to that? Well, of course, Hunter and Southam said, well, we object to that because there has to be a prior judicial authorization.
the Big M Drug Mart case, which I believe is an Alberta case. The Department of Justice thought, well, who ever heard of a drugstore with religious convictions? Large corporate chain. Well, the Supreme Court said, yes, they're entitled, even if they don't have religious conviction, to take advantage of a law that provides, in the case of that, the Lord's Day Act that denied scope for religious conviction. I argued the case of Operation Dismantle, which I thought was of a great importance, because I contended to the Supreme Court that this was a political issue as to whether or not it should be possible to test the cruise missile in the Mackenzie Valley. And because it involved NORAD, it involved treaty obligations, it involved highly technical information, it involved areas of expertise that were simply foreign to the court. And of course the political questions doctrine is deeply entrenched in the United States because of their doctrine of the separation of powers. And it seemed to me a reasonable position to take to the courts that if you really are not familiar with this entire area of government operations, there is some basis for restraint. And what I had not bargained for was, at the time, the court was on a mission to make it clear to Canadians that the Charter had enormous bite, and they were not going to be seen to be backing off a fight with the government. And as Justice Wilson said in that case, in response really to my argument, she said, the question is not whether we can deal with these matters, the question is whether we must. Now, that seemed to me at the time completely illogical. You know, if you're not able to deal with it, maybe you weren't intended to deal with it. But it was a signal from the court in all of these cases that, far from being the model of judicial restraint which had been expected, I don't think by Trudeau, and I don't think by the members of the parliamentary committee that reviewed the Charter, but I think by the legal community and certainly by the government lawyers, a misapprehension as to just how far the court was prepared to go with the Charter. The problem, as I see it, is that over the years, since those early cases, civil rights groups have become more and more reliant on intervention by the courts, at the risk of losing the ability to mobilize public opinion and losing the support for the cause. For example, of police powers and the G20. Now, in my 7th hour as a non-judge, and not knowing the facts of the G20, I think that people ought to be extremely concerned as to what went on. But how are they going to be concerned unless this is communicated to them as something they ought to be worried about? Because, of course, Chief Blair has been extremely effective at going on television and saying everything we did was fully authorized by law, it was justified by the circumstances, and so on and so forth. And at the end of the day, public opinion is going to have a much greater weight than a number of decisions by the courts, either in the individual cases that are brought or in various challenges to police powers. The court now is entering a phase where groups like the Civil Liberties Association are becoming somewhat disillusioned, disenchanted. The code word in the CCLA literature is disappointed. They say, you know, the CCLA welcomed the decision insofar as it said that, but we are disappointed that the court did not go further and accept our point on this other thing. Well, I think that insofar as the courts have a role to play, and there's no doubt that it's an extremely important role which the courts will continue to play, but we are now past the euphoria of the 80s and the 90s when the court was laying out broad general principles, and we are now into an era where people are testing the limits of these principles. And when you are striking at the limits, you're not always going to succeed. And if you do always succeed, that's a sign that you're not challenging enough, because you're only challenging it when it's safe to challenge. In many ways, the success of your mission is the number of cases you lose, because it shows that you're continuing to push the envelope and making the court stand up and say, well, this has gone too far. And I'm going to give just a few examples of where I think this principle is operating, most of which have had the benefit of the intervention of the sponsoring organizations here, but in all of which they have expressed some, quote, disappointment, unquote. Years ago, I acted for the Canadian Broadcasting Corporation involving a TV show called The Boys of St. Vincent. That was about based on the Mount Cashel abuse of children by the Christian Brothers. A trial was taking place in Eastern Ontario in which a trial judge issued an injunction against the CBC prohibiting the broadcast of this film on the basis it might influence the jury, which had not then been picked. I have to say, oh, good God, this is more help from the CCLA than I've ever experienced. The lower courts upheld the injunction. The Ontario Court of Appeal upheld it on the basis that you cannot interfere with a fair trial. Went to the Supreme Court of Canada, and of course our response was, look, when the CBC puts on a show, it is safe to say that 100% of the Canadian population doesn't watch it. All you have to do is to say to the jury pool, would those who saw The Boys of St. Vincent please excuse themselves, and your problem walks out the door. But such was the mindset of the judges on fair trial interests that cut no ice until they got to the Supreme Court, and the Supreme Court laid down very broad principles that freedom of expression was a value just as entrenched in the Charter as was fair trial rights. But what you have to notice, it was an easy case. I mean, it was ridiculous to enjoin the broadcast of a fictional docudrama on the strength of a trial taking place in Mont Albert in Eastern Ontario. But you had this general principle. So the civil liberties crowd, if you don't object to being referred to in those terms, said, well, you know, we're off to the races. So in more recent cases where you've had disappointment, for example, on the reporting of bail applications. Well, I think that bail applications is a very tough case. Somebody gets arrested, they're dragged into court. Think Dominique Strauss-Kahn turning up on the Perp Walk in New York City, unshaven, disheveled, disoriented, and the prosecution reads whatever it wants to read into the record, and the accused at that point is in no position to respond. Now how does the public interest in freedom of expression outweigh the interest of that accused at that time in some protection against the dissemination of what may turn out to be completely false and unreliable information? So the broad sweeping principle comes up against the hard reality of the case. In another instance, freedom of expression, the National Post on the confidential sources issue, journalistic privilege. The CCLA argued that there should be a constitutional protection of journalistic sources. And the court decided no, that the news gathering operation, while it was protected by the Charter, did not entrench in the Constitution every method and mode of news gathering, whether it's checkbook journalism or secret sources or whatever, that the constitutional protections were at a higher level of generality. And so we proposed a test that it was where the public interest in the suppression of the name of the confidential informer exceeded the public interest in its disclosure. And in a subsequent case, in the Globe and Mail, the reporter whose sources led to the whole Gomery Commission and the scandal, the court said yes, in that case, suppression was more important than disclosure. But you're now hitting at the edges of what freedom of expression in its constitutional dimension requires. You're into much more difficult cases, and you're going to lose a lot more cases than you did in the halcyon days of the 90s, when a lot of very general principles were being established in quite easy cases. But just on that point, there is no reason why, if you feel strongly that journalists should have this privilege, even where the balancing would favor disclosure of the source, there are journalists' source shields laws in effect in many of the US jurisdictions that say sources are simply not to be disclosed in courts. So that is where political pressure brings about a result. It's not mandated by the Constitution, but it's certainly permitted by the Constitution. And it seems to me that it strikes a proper balance between what is essentially a field of political judgment, as Alan Borovoy, I think, accurately saw some years ago, and constitutional litigation, which entrenches these measures really beyond recall. I mentioned several times this work on the G20. We've had a number of cases on police search and seizure. And those cases are difficult because there is a countervailing public interest in the investigation of crime. And there is only so far that a privacy interest can be set up against it. And we had the CCLA and perhaps some of the other associations before us in the great garbage case, the Patrick case, where it was argued that a bag of garbage thrown out at the roadside for the garbage man to pick up could not be seized by the police. Well, when you have a fundamental principle of privacy, you have to, as a judge, look at the limits. It's not enough to state privacy is protected. You also have to say, at what point does privacy cease to be protected? And in the case of the garbage, which I agree was full of information, the CCLA term was the bag of garbage is a bag of information. I not only quoted them, I credited the quote to the CCLA in the judgment. But if the privacy interest doesn't cease when you throw the garbage bag out to be collected, when does it cease? I mean, does it cease in the garbage truck? Does it cease when it gets to the dump? Does it cease when it rots into dust and mold? You have to have some practical lines so that the police know where they stand. You can't just leave these things indefinite, saying, well, a privacy interest is a privacy interest is a privacy interest. But the moral I do draw from that is that this work you're doing on police powers is of exceptional importance because Canada lags behind, I think, every other common law country in codifying what the police can do and what they can't do. when we had the litigation involving sniffer dogs, and whether they could be unleashed at bus stations and in schools without any warrant and really without any reasonable suspicion of the presence of drugs. We discovered in almost every jurisdiction laws governing when sniffer dogs could be used and when they couldn't. No such laws in Canada. Now that, it seems to me, is an absolutely vital thing. Anybody interested in civil liberties, to have the police operating within certain constraints so that they know where their power begins and where it ends. Well, I don't want to go on too long in all this. I think I've probably said enough to make my general point. I do think, you know, that Professor F.R. Scott, who was the great constitutional law professor in the 50s and 60s, said there are really three fundamental requirements of civil liberties. One is a legislature that is conscious of the need to protect civil liberties. The second is an executive that has a sense of responsibility to enforce civil liberties. And the third is a vigilant public. And it was interesting that he didn't mention the courts at all. The courts didn't figure in his calculation, even though he was, at the time, probably the preeminent constitutional scholar in the country. And I think, and I know you've all been very heavily involved in the anti-terrorism legislation and the Cadre case and cases and so on, but you know, you have to put this into the mix. Canada is one of the few countries where the anti-terrorism legislation is expressly made subject to the Charter. If you look at the United Kingdom Anti-Terrorism Acts, it's in derogation of the European Convention on Human Rights. In terms of the executive, of course, there are all sorts of disagreements with the way in which the anti-terrorism legislation has been utilized. But we did have the Maher Arar inquiry, we did have the Yakabuchi inquiry into others who had been detained in Syria. And in fact, in a report by the International Commission of Jurists in Geneva, Canada was singled out as having an executive that it was at least concerned about what happened to people, and was prepared to call an inquiry which gave a very unflattering view of the way in which the executive was discharging its responsibilities. And as to a vigilant public, I think there is a big job, because I think the press is not as vigilant as it might be. The columnists, you know, tend, seems to me, to be a little further to the right than most of the population on some of these questions. And there has to be a kind of mobilization of public opinion that civil liberties have to be taken seriously. And I know that's what this conference is about, and I congratulate you on the work that you've done and at the work you're going to do. And on behalf of my former colleagues in the Supreme Court, I thank you